Can my employer fire me without 3 written warnings? The answer is yes. The idea that you're required to get 3 written warnings is an absolute myth, a fabrication, circulating around some HR departments, but is not true. An employer, first of all, can fire an employee on a without cause basis. This means the company is not asserting that the termination is the fault of the employee, and they will be complying with notice or severance entitlements. Now, when this happens, I'd say greater than 9 out of 10 instances, the employer will offer less termination pay than you might be entitled to, and it's a good idea to speak to a lawyer. If an employer wants to deprive the employee of severance pay, they may assert cause for termination. Now, even in these circumstances, they may not be required to give written warnings at all. For example, if an employer finds an employee stealing money, they fire them on the spot. They don't need to give 3 opportunities to improve or stop stealing. If an employer wants to terminate an employee for performance-related issues, it's very difficult to do so, and they'd be required to demonstrate to the court that they've given the employee numerous warnings and every opportunity to improve. This can include even offers for coaching and further training. It should be clear that there was a progressive discipline if there's some kind of a breach in workplace etiquette or misconduct, and the written warnings will be useful in helping an employer prove that they've taken the necessary steps to assert cause for termination. But again, there's no strict 3 letters, 3 strikes and you're out rule. Many instances will require far more than 3, and even with 10 warnings, depending on the kind of conduct, the employer may still fail to make out cause for termination. And as we mentioned, in other cases, you can fire without a single warning letter. It's very much a case-by-case basis, but to answer the question, no, you do not require 3 written warnings to terminate an employee.